Right, so let's kick off. Good morning, everyone, or good evening. Welcome to this, the third webinar in our series focusing on M&A in times of disruption and transformation. My name is Ben Mercer, and I am a partner in our corporate and M&A team based in London. The first of these webinars a couple of weeks ago focused on the overall M&A environment given the continuing effects of the pandemic, war in Ukraine, rising inflation and interest rates, and Brexit and supply chain constraints. The second webinar dug into rising regulatory hurdles and including merger control, the UK National Security and Investment Act, sanctions, pensions regulation, financial services regulation. Both of those webinars are available to view on our website if you want to catch up. This webinar is going to focus on some of the more deal-specific technical areas where we have witnessed change over the last couple of years and their implications for M&A. The session was billed as looking at the new normal, with markets and economies starting to stabilise as lockdown restrictions have eased, though we also need to consider other curveballs which have been thrown at M&A markets over recent days and weeks. I'm joined today by a panel of experts from around the SH network. Paul Reeves is a partner and head of our employment team in London. Simon Bollens is a partner in our commercial and technology team in London. Katie Hewson is a partner in our data protection team, also in London. And Brian E. Roy is a senior associate in our competition team in London as well. We were due to be joined by Jean-Julien Lemonnier, a partner in our competition team based in Paris, but I'm afraid he's suffering some technical problems this morning, but hopefully will still join us. Before we begin, I would note this session is being recorded and will be available to view later if you have enjoyed it. Like BBC Question Time, there is a Q&A function, so please feel free to ask questions and I will try to raise them as we go or at the end, and I really would encourage that, please. Alternatively, feel free to email through any questions to me or the team and we will come back to you at the end of the session. So let's start with Paul. I'm sure everyone remembers the introduction of the furlough scheme at the start of the pandemic in 2020. But is the furlough scheme still an issue in corporate deals?
The short answer is yes, it is. The reasons being that there are associated reputational and financial risks. Although the schemes have now ended, a number of people sought to claim under those schemes. And so we're still asking a lot of DD questions and being asked questions about how companies used and how they applied that particular scheme. You've got to bear in mind that the government have invested over 100 million in a task force to seek to recover up to £1 billion worth of furlough support that may have been claimed fraudulently. So that's really where the aim of the DD questions are. So if we look at it from a buyer side and then a seller side, just some of the considerations that you need to be thinking about. So from the buyer's side, your concern is mainly, has there been any misuse of the furlough scheme? For example, were people working when they shouldn't have been working? You'll remember that when the furlough scheme first came out, it was issued with a lot of guidance and not legislation. So it was very hard to interpret what the government actually meant because they were making up as they went along a little bit and they were reacting to a situation. So it was very fast paced. So they didn't have the luxury of being able to consider it very carefully. So there is a lot of scope for it to have been erroneously claimed, not fraudulently, but there are also a large number, given the investment that the government's made, there's a large number of fraudulent claims that they're looking for. So from the buyer side, checking, did they apply it properly? Was anybody asked to work when they shouldn't have worked? Checking how was the scheme applied for? Were any mistakes made in the application process? And if those mistakes were made, and they were genuine mistakes because of the way that we were reacting to the time, has anything been done to rectify those mistakes? And if there hasn't, then you as a buyer may want to request the seller to take appropriate steps in those circumstances. From a seller's side, we're really interested in how much was claimed, in respect of which employees, what process did you follow, and the steps taken to ensure that there were appropriate systems and controls in place so that you didn't fall down, they didn't fall foul of it. And if they do, as part of the DD process, uncover any errors, that you as the seller are ready to either rectify that however is necessary. So it is, although it's all ended, it's still an important aspect of this because of the, as I say, the financial and reputational harm.
Great. Another area I was going to ask you about is redundancies. There's been quite a lot of press coverage recently about companies needing to make large-scale redundancies, P&O being the most infamous example, I think. What do we need to know about redundancies in an M&A context going forwards?
Yeah. The number of times I've been asked, was I advising P&O and in respect of this? I think the short answer, just to allay any suspicions, no, I wasn't. P&O was a case on its facts and quite unique. And if you're prepared to pay significant sums of money and flagrantly breach English employment laws, that is the model to follow. There's a lot of information that the press haven't really picked up on in terms of the sums, etc., and the way that they handle it. So I think the takeaway from this question is don't follow the P&O model. The things to bear in mind in a corporate transaction are, particularly where you've got collective redundancies, and there's a few things that you need to be aware of with regard to collective redundancies. First of all, you've got to notify the government, the BEIS, through something called a HR1 form. It's a very simple form, but often overlooked, and that's a key form to complete because a lot of dates trigger from submission of that form. There's a bit of a common myth with regard to English employment law that you have to consult for a specific number of days. I can assure you there is nothing that says you must consult for a maximum or a minimum number of days in English employment law. If you think about it, if it did, quite a lot of employers would just run the clock down. So the dates that you probably have heard about are things like the 30 days or 45 days. Those dates relate specifically to when the first dismissal can take effect. So if you've got 20 people or more being made redundant in 90 days, you must consult for as long as is necessary, and the first dismissal can't take place within 30 days. If it's over 100 people, then the first dismissal can't take place in 45. So that's what the 30 and 45 days are. So don't confuse the two, that I've got to consult for that amount of time. If you get it wrong, and this is one of the things that P&O did do, they just paid out the compensation for breach of the legislation. Because if you get it wrong, there's something called a protective award. And a protective award, effectively, is 90 days pay per person of their actual salary. So when you've got a large workforce and you don't do it properly, that can be quite a significant sum. So that's something we're always looking out for in M&A transactions. There's usually a bit of a conflict as to whether redundancy should be taking place now or in the future, and that then becomes a pricing point, or maybe there's some apportionment to actually who handles it, who picks up the cost of the redundancies. One other point I would make in respect of this particular topic is where you've got an asset sale, so a TUPE transfer, and you've got a collective consultation. The good news is since 2014, you can run those two processes in tandem rather than have to do a redundancy and a TUPE consultation at the same time. So just be aware that you can run the two together, but the key part to that is that both seller and buyer need to agree that that is how they will handle it. So I think the key takeaway is the law hasn't changed, no matter what you've read in the press about P&O. There are a lot of hurdles to go through, and those of you that I deal with regularly on this webinar, English employment law loves process, so there's a lot to be done with regard to process in this area. So something to keep an eye out, and also look at in the lead up to any purchase, have any redundancies been conducted in the recent past, and how were they conducted, to make sure that there's no legacy issues there.
Great, thanks, Paul. There have also been a lot of cases and press coverage recently, certainly over the last couple of years, about workplace culture. Your favourite cricket club, Yorkshire, being among them. How are you seeing that play out in relation to employees and in the context of M&A?
Surprisingly, it's nearly 5 years since the Me Too movement really came to the fore. And so when the Me Too movement came to the fore, this issue about behaviour in the workplace, culture, etc., was on the radar of most companies, but suddenly elevated into the top 3 issues that were concerning a lot of our clients. And since then, we've been doing a lot of work with clients in terms of educating staff to remind them of what is and isn't appropriate behaviour in the workplace, because it may seem obvious how to behave and how not to behave, but that does get forgotten, particularly at work events. And although we've obviously been in lockdown for the majority of the last few years, interestingly, the stats show that the number of issues of harassment or bullying in the workplace has gone up, even though people are working remotely. You'd think that because they didn't have the luxury of going to work events or after work events or drinks events, that you would have expected maybe a levelling off or even a drop off. But because of the rise of instant messaging, the use of video calls, more reliance on email, etc., people have become a little bit too informal, and you're seeing a lot of perhaps inappropriate chat, particularly on instant messaging, and GIF images that are put on those messages. That from an employer's perspective and from a buyer's perspective particularly, there's quite a bit of reputational harm that could come with that. So you're absolutely right, Ben. There's been a significant number of cases starting to come through, with some with large sums of money. There was a recent international bank that had a claim against it where the individual received over £2 million in compensation because of the bad treatment. So as a purchaser, we're always interested to know if there are any investigations, grievances, disciplinaries, or even tribunal cases, because the issues there can be that the reputational and the financial harm for that can be quite considerable. So it is something that needs to be on the radar of anyone who's purchasing. And as a seller, you need to be prepared and ready to answer those questions as to what are you doing to deal with that issue, because once these cases do get in the press, it's a difficult tag to lose. And as you've seen with the Yorkshire Cricket Club, it can have severe reputational and financial consequences. In that instance, a lot of sponsors disappeared and you lose good revenue streams.
Great, thanks, Paul. I'd like to bring Katie in now. So we've heard a lot from Paul about some of the data-related issues that arise in an employment context. We're also seeing a lot more cyber and data issues being raised as key issues in deals since the start of the pandemic. So Katie, what are you seeing on this?
Yes, we're certainly seeing an increase in the sort of cyber and data risks and the focus on those in an M&A context. The DCMS, for example, published a survey just recently, I think it was last month. The key findings were that 39% of businesses reported a cyber breach in the last 12 months. Apparently, among those businesses that have experienced breaches, only 62% take action to prevent further breaches. And just over half of businesses have acted in the past 12 months to identify cybersecurity risks. So in an M&A context, there are increasing cyber and data risks in most target assets. And data sharing for the purpose of the deal itself is getting more and more risky. There's a few reasons for this. The move to remote working, some of the factors that Paul was just discussing, use of home networks, the huge shift to remote working meant that many workers were working from home, using personal devices to access very sensitive information, confidential information. The move to home working was often carried out quite quickly without sort of proper normal procedures in place. And so as a result, initially at least, and potentially even still, there's not the same level of protection where you are working from home. There's also this move to working from abroad as this new normal. Some people are, lucky people are getting to do this. And again, that's not always been done with sufficient kind of thought about the cyber and data risks there. So in that case, if you're working from abroad in particular, your data, particularly personal data, but any confidential data, will be more vulnerable to local laws, allowing local authorities to access data potentially, which creates lots of risk. So these factors mean that organizations are generally more vulnerable to attack. But obviously, we're all kind of used to this new hybrid mode of working now. So it's important to kind of get this right post-completion. Another factor in kind of increasing risks has been increasing reliance on cloud technology. Now, there's nothing inherently insecure about cloud technology for storing data, but obviously, again, traditional security solutions don't always work on that, and it hasn't necessarily traditionally been enough focus on updating, upgrading those security solutions where you are moving to the cloud. And then on top of that, we have the cyber security risks in the current geopolitical situation. So we're seeing an increase in nation state backed attacks. We had a cybersecurity survey. It suggested that Russian and Chinese state-backed groups were responsible for nearly half of all sort of observed threats in 2021, and that's only increasing with the recent war in Ukraine. There's been lots of reports of attempted threats and attacks there. So we have an increase in cyber risk for all targets to be aware of.
Great, thanks, Katie. So given all of that, what steps should a target take to prepare for an M&A transaction?
Yeah, so I mean, it's the obvious stuff, but you have to be aware of more scrutiny that will be placed on it by people like me. So preparing your disclosures of policies and records, you might need to be prepared to get more granular and disclose more. Prepare in advance to answer questions on incidents and complaints, because that's where a lot of the attention is being focused now. You obviously need to work with lawyers and technical specialists to disclose appropriate information, both legally what your procedures are and sort of in reality the technical security procedures that you're following. And also another factor that's often a complicating one is to prepare by reviewing the data that you're sharing with the rest of the sort of sellers group. You obviously, I mean, it's fairly obvious, but it's often quite complicated. You'll need to ring fence the data that is going to be transferred over and assess what data you're relying on day to day, customer databases, staff lists, and prepare for sort of access changes to those. And often even just mapping that data and that data sharing hasn't always been done before. So getting to the bottom of that and how to carve that out is often a really interesting and complex piece.
Yeah, great. And then on the other side of the coin, if you're acting for the buyer, how do you normally approach the DD and what sort of level of protection are you looking for?
Yes, so as I mentioned, a key thing that we're seeing at the moment is that we're working with a technical specialists. So obviously the kind of security technical specialists are doing their own increasingly detailed cyber and technical due diligence alongside the lawyers. So we're often working with them to kind of ask each other questions, share information to really bottom out the cyber and data risks in a target. Lawyers can obviously check that the policies say the right things, but the key risks are sometimes what's actually happening on the ground, whether those policies and procedures are being followed. So that's a key thing that we are seeing more and more of a focus being put on getting that sort of on the ground due diligence done. It's important to get data protection and cyber due diligence right. Again, same risks as Paul mentioned, really the reputational risks of that, as well as the financial risks. After we saw the Marriott fine a couple of years ago, 18.4 million, and that was obviously data cyber risks arising post-acquisition that had been in the Starwood Hotels Group, that had been those issues had been there before the acquisition, only kind of came to light a few years later. The buyer was held liable for that fine by the ICO. So we're seeing this kind of high risk, both financially and reputationally. Protections, I mean, the appropriate protections will obviously work on those depending on the deal, depends on the risks you identified. Disclosed risks, if they've been disclosed, they obviously can't normally benefit from warranty protection. So you might be looking for indemnities for specific risks, and they're often agreed. Indemnities won't normally cover conduct that takes place post-completion, though. Obviously, there's a kind of usually a bit of an argument about that post-completion indemnification piece. So it's really important to get the drafting right and to get some good lawyers to help you negotiate that.
Yeah, I think I know one. So, so drawing that together, what would you say are the key cyber and data issues that you're seeing arise in acquisitions post-pandemic?
Yeah, there's a much greater desire than maybe a few years ago, an understanding of the risks that data can pose, and a desire to really get to the bottom of it in reality. So gaining a proper understanding of the nature of the data that's held, especially where it's a key part of the value in the target. How and where is it stored? So thinking about what privacy laws internationally may apply is a key issue that's coming up at the moment. More and more jurisdictions are putting their own data protection and data sort of access laws in place. And often they're very different to GDPR, and in some cases can require, for example, data localization. So locally mandating that a local copy of data has to be kept, or certain data cannot leave a country, for example. So there can be some really difficult international data protection laws to consider as part of an acquisition. So that's coming up quite frequently. Cyber insurance is another one that we're seeing. Obviously, lots of companies have that in place now, but looking at those existing policies, trying to work out if they'll need to be changed, the coverage will need to be extended post acquisition. So focusing on what the terms of those policies say. Buyers are requesting more and more information on data breaches, asking a lot of questions about complaints, potential enforcement action, really getting into the nitty-gritty of those details. So sellers should be prepared to disclose as much information as possible as they can on any incidents, even small ones. There will be scrutinized maybe more than they were in the past, because information about complaints can be an indicator that there are sort of latent issues that need to be uncovered. So something that the lawyers often focus on. Another issue we're seeing is looking at the target's own cyber defenses and cyber protections and arrangements. Are they compatible with what the buyer wants to do? What measures have the seller suppliers and contractors taken to strengthen their own cyber defenses? So not just the target itself, but its affiliates and its related parties, and identifying weaknesses in those defenses. And then interestingly, there's also just the data sharing piece in the deal itself. So putting data into the data room, ensuring that that's sufficiently minimized and redacted so that you're not disclosing unnecessary personal data as part of actually doing the deal itself. And when you're sharing data, particularly internationally at the moment, with the counterparty in the deal, there can be additional safeguards and protections that are needed purely just to do that, let alone post-completion. So that's another interesting and complicated factor that's coming up more frequently now.
Great. Are there any other developments or trends that you note in the data protection arena that we in M&A should bear in mind?
Yes, so two key ones I wanted to highlight, I suppose, in tribute to Paul, subject access requests, data subject access requests. We're seeing more and more of those at the moment. Obviously not particularly in an employment context. It's not in itself, a key M&A issue, but it can indicate a potential high liability on the employment side. Also, they can actually just be very expensive to deal with in themselves and very time consuming and burdensome. And we're seeing a big increase in those. And I don't know, I'm speculating there might be something to do with some of the issues that Paul has raised. So those employment kind of controversies working their way down into subject access requests at the moment. And seems to be a really big spike in those. And they're becoming something that we're scrutinizing more and more as part of due diligence and getting to the bottom of what the risks are there and the potential financial consequences. Aside from that, the government has also announced in the recent Queen's Speech a few pieces of legislation that will have an impact on UK data protection law. They've got this data reform bill that they've announced. And the idea behind that is that it will be, pro-innovation, pro-research. It's supposed to, cut red tape in data regulation. But it does potentially mean that we could be moving away from the European model, the GDPR. We don't know the details yet, but the government certainly wants to kind of make its own way, which is fine in itself. But the problem is it could endanger our own adequacy decision, as they call it, from the European Commission, which will increase the potential red tape, required to share any personal data from the EU to the UK. So if you're doing business with, if you're doing a deal, for example, with a European counterparty, or there is a target with any kind of international EU, UK kind of footprint, actually there could be a lot more headache and burden in terms of paperwork required to share personal data if we do lose that adequacy status. So you know, that's just something to kind of bear in mind. There's also the EU is itself publishing a lot of new regulation and data related legislative initiatives at the moment. So it's a really kind of fast moving area. And if data is a key part, personal or non-personal data is a key part of what the target does and how it makes money, that's something to really get your head around, like what the impact of those legislative changes coming up down the line this year, potentially, what the impact of that is going to be on the target's business.
Great, wonderful, thank you, Katie. So having heard about some of the tech issues at play in relation to cybersecurity, let's move on to Simon. So I know we've been seeing a lot more issues on M&A transactions over the last few years relating to the use of open source software. And it would be great if you could give us a feel for how these issues have been amplified during the pandemic. So how has the landscape changed over the pandemic years, and what are the key M&A risks?
Yeah. So thanks a lot, Ben. Well, to set the scene before we get into the impact of the pandemic and the risks on M&A type deals, I think it's worth first providing some context to the use of open source software more generally. And in particular, there's been a real increase in the use of open source software over the past sort of 5 to 10 years, with more and more proprietary platforms being built using open source components. And this is really because there's a huge body of freely available software and components that have been developed specifically for use in the wider tech ecosystem. And so a lot of cloud platforms are now built on scalable and interoperable open source models. In particular, many businesses want to tap into these pre-developed resources that are often extensively peer tested, and in many instances are maintained and updated for free. So for example, back in 2011, so just over 10 years ago, we were seeing that only around 50% of tech companies were using open source software, whereas studies from last year showed that around 95% of tech companies admitted to using it. And it's likely that the real number is actually sort of much higher. So now even the likes of Google, Microsoft, and IBM are all allowing the use of certain open source materials, whereas 10 or maybe even 5 years ago, the use of anything open source would have been largely prohibited in a lot of big tech. So it's not sort of taboo anymore, and we're seeing sort of much more widespread use in the industry. And then in terms of the pandemic, what we've seen over the past few years is a huge global increase in the demand for technology. Those businesses sought to adapt to meet the needs of their remote workforce, and also to tap into market demand for new digital tools and applications, for example, new communication and collaboration tools. And the use of open source software has sort of helped deliver this as it accelerates the development life cycle and reduces the time spent to get new products on the market. So for example, a TideShift survey in 2021 found that 68% of organizations had increased their use of open source software, open source materials during the pandemic to save money and time in rapidly developing out their roadmap. However, sort of coupled with this increase in use, what we've been seeing in particular with startup and growth businesses is that they haven't implemented robust compliance controls around the use of the open source software. And this seems to have been overlooked until quite late in the days, such as at a key investment round or on an exit. So the pandemic has kind of fueled the prevalence of the issues rather than created them. So for example, I've just been advising on a mid-market deal where the target had zero open source compliance in place. So they knew they'd used it in the development of their platform, but they had no idea of what components they'd use and on what license terms. So from a diligence and risk perspective, this was quite difficult to navigate. And I think this is just an example of which there've been quite a few over the past few years. So in summary, whilst the pandemic hasn't directly brought about the issues and risks, we're seeing the issues more frequently, because of the boom in tech growth coupled with increased deal activity and what we're seeing of this more relaxed approach to compliance. And so then in terms of what the risks are on deals, this really depends on what the license types, what license are being used for these open source components. And there are sort of three broad types. So one category is referred to as permissive licenses. And these are licenses that typically have few restrictions and are generally compatible with proprietary use. And this includes the BSD and MIT licenses, which are quite popular. So generally speaking, they allow you to use the license component, provided you just credit the underlying author. So these types don't really create any material risk on an M&A deal. Then there are the copyleft licenses, and these are the ones that create the key risks. So the effect of these licenses is that if you use a component on a copyleft license, such as from the GPL license family, you really run the risk that your proprietary code also becomes open source, and so should also be made available for others to use on those same open source terms. So basically your proprietary code becomes infected with the copyleft license terms. And these are the license types that are the most concern on a deal, in particular because there's a huge risk that the value in the target's software is completely eroded, basically because you have to make it available for free. And then the last category is more of a subset, and this is referred to as weak copyleft. And so the main difference here is that the terms have a less infectious copyleft effect. So they might allow certain uses, such as dynamically linking to the code without infecting the wider program, or the copyleft effect might only apply to the specific file in which the open source component is used. So this type of license can be okay in a wider piece of work, provided it's been used by the company in a particular way. And then the other risk, in addition, and sort of irrespective of the license type, is also security risk with some components, and sort of in particular, where the target has failed to keep the code up to date. So for example, on a recent deal, the target was using an open source platform that had a known security vulnerability that could have allowed a third party to hack into its systems. Then this hadn't been remediated because the target didn't have a policy in place for checking and implementing new updates. And so as part of a transaction, this was quite a significant risk that had to be addressed. So really, in summary, the use of open source materials itself isn't a red flag, and there are a lot of advantages to using it, such as the cost and time efficiencies. However, there needs to be, care over the components and license types used and how the target keeps them up to date. And as I said, in particular, with those tech businesses that have grown significantly during the pandemic, when they've been concentrating on growth, what we've seen is a more relaxed or even non-existent approach to open source compliance.
Yeah. So given all of those different risks that you've outlined, and there are a few and it's complicated, how does this play out on deals, and what specifically are you looking for as part of the DD?
Yeah, so I mean, from a due diligence perspective, what we're looking for the red flags on the license types, and also general warning signs of poor compliance. And then coupled with this, the buyer's technical advisors are checking the code base from a stability and security perspective. So for example, we'd expect the target to disclose a well-documented asset register, so something setting out which open source components are used, what license types apply, and a brief explanation of how those components are used in the wider platform. And then, the purpose of this is that evidence is that the target has a good housekeeping, and it enables us to spot, the potential risks, such as if one of those copyleft licenses is included in the component list. And then together with that, we also check to see if the target has a documented open source compliance policy, setting out the company's overall approach to the use of open source materials and any restrictions. And then so what, and what we're finding and what happens is they don't have either of these. This is another red flag, because we can't check against what the actual risks are or get a feeling for their approach to compliance. And so if this is the case, the purchaser or investor has to consider the extent to which they can rely on any of the warranties, or what indemnities we might be able to obtain, or if they want to engage a third party to conduct a technical audit. And this would be a sort of a technical audit of the code so that we can understand the open source components and license types used in that code base. The issue with this is they can be relatively expensive. Although that said, I've seen more of these carried out in the past 12 months following the pandemic. So I suppose then, based on the information of the components and licenses, assuming this has been disclosed or obtained from an audit, we then do a high-level analysis of the license types, and what we look out for is whether any licenses are used that we know are problematic, such as from the GPL license family, or those that we aren't particularly familiar with. And then typically in consultation with the buyer's technical IT advisors, we do a more analysis as to whether there are any problematic uses, in particular, whether there is a risk of any copyleft terms affecting the wider code base. So really, we're doing sort of a desktop exercise to pull out and investigate any problematic license use. And then the technical DD providers are also looking at sort of security and stability of the sort of underlying code.
Great. So when you do pick out some examples of non-compliance through the DD or through one of those technical audits, how do you typically look to deal with that on the transaction?
Yeah. Okay. Well, in terms of the deal protections, this is sort of typically a combination of the normal general warranties that are disclosed against, together with specific indemnities to apportion risks on any red flags. And so from a warranty perspective, this falls into sort of two broad categories. So the first, when acting for the buyer or investor, we'd seek warranty protection that the target is aware of the open source materials and is able to disclose how these components are used and kept up to date. And then the second element is then seeking warranty confirmation that the target is in compliance with the relevant open source license terms, or at least in sort of material compliance, and that the use of the open source components don't require any of the target's proprietary applications to be made available on an open source basis. So, seeking protection, they haven't used any of those copyleft licenses, or where they have, that the particular use that they're saying they use them for doesn't trigger those particular requirements. And so these are the sort of main two areas that the target needs to disclose against. And then, depending on what we've uncovered from the due diligence or the disclosures, we might then suggest some specific targeted indemnities on those material risks. So, for example, we might suggest a specific indemnity to cover the impact of a potential claim that the platform might need to be made sort of available as open source, and allocating the cost of remediating that code base in light of any claim. In addition, or as an alternative, we might also suggest sort of specific remediation work is undertaken. So that could be substituting the code that we've identified for that under a different license, or obtaining a commercial paid for license to cover the target's use so that you're not using it on an open source basis, or just updating the particular components to the latest versions to remove any highlighted vulnerabilities. And more and more, in many cases, we're advising these steps take place before completion to sort of narrow that risk. So in summary, there's quite a few issues to consider, and in some cases, the risks have been more difficult to assess over the last couple of years during and following the pandemic, because it can be more difficult to get that full picture of the open source materials that have been used. So this really keeps us quite busy on deals, and also when supporting clients prepare for a sale or an investment round.
Great. Thanks, Simon. All very interesting. I'm delighted to see that Jean-Julien has now joined us. I'm sure Brian is also delighted. So let's turn to competition and antitrust. So perhaps let's kick off with Jean-Julien. Perhaps you could give us an overview of the way in which the pandemic has impacted M&A transactions from a competition perspective.
Sure. So as we all know, COVID gave rise to crisis situations in various markets in the world, primarily resulting from shortages. The competition rules were relaxed in various sectors to enable companies to cooperate in ways that they are not usually able to, just to try to allow them to respond to the emergency situations they were facing. However, at the same time, the competition authorities also been very clear that their intention was not to allow companies to take advantage of the pandemic to breach antitrust rules. So even though the daily work of the competition authorities was slowed down by the crisis, merger control in the form of merger notification rules has not been relaxed. On the contrary, competition authorities remain very active and continue to frustrate deals in 2020 and 21. For example, in 2021, we had 91 cases with remedy, 11 deals prohibited, and 19 deals abandoned due to antitrust concern all over the world. So why were competition authorities not so keen to relax the merger control rules? Well, the answer is quite simple. M&A operation impacts market structures. First, competition authorities cannot allow these structural and durable effects merely on the ground that the last 2 years have been exceptional. So a good indicator of the non-relaxation of merger control rules is the absence of increased approvals based on the failing from defense theory. For those who are not familiar with this, it is a situation where a competition authority clears a potentially problematic deal on the basis that at least one of the merging firms would rapidly fail in the absence of the contemplated merger. We have seen very few competition authorities applying this failing from defense theory during the last 2 years. We have one example in Malaysia and one very recent one in France. We have also found an example in the UK where the authority refused to apply it. So the expected broad application of this theory has simply not happened. Beyond this, it is worth mentioning that the crisis has not put an end to the ongoing complexification and expansion of the scope of merger control rules. Indeed, in many jurisdictions, such as Austria, Germany, or Turkey, reforms have been implemented, while in some other jurisdictions, like in Luxembourg, we are considering the implementation of a merger control regime for the first time. Also, at the European level, last year, the European Commission expanded the scope of the referral mechanism set out at Article 22 of the merger regulation by encouraging national competition authorities to refer certain cases for review by the European Commission. In particular, in the digital and pharma sector, even when their own national jurisdiction thresholds are not met. This is to prevent the so-called killer acquisition. That is a situation where you buy a promising startup in the purpose to kill a future competitor and its innovative products. For the moment, the poster case for this new Article 22 referral is the ongoing Illumina Grail case. It's in the pharma sector. The deal is very sensitive because Grail is active in the cancer diagnostic market, and the European Commission wants to ensure that this deal will not negatively impact the launching of multi-cancer screening tests.
Right. Well, it certainly sounds as if deals are becoming more complicated from a competition perspective. Are there any other things that companies need to be aware of in the context of the merger control regimes?
Yes, lately we've seen that many competition authorities are issuing more and more decisions sanctioning procedural breaches. This is true for antitrust investigations, but also in merger control, where procedural breaches may occur in various cases. For example, companies may fail to notify a transaction. They could also implement a transaction before obtaining regulatory approval. This is known as gunjumping, or provide misleading information during the merger control review. The failure to notify decisions are increasing, and there are few recent examples in Spain, China, in Morocco. In Spain, for instance, the competition enforcer has accused 2 funeral services providers of failure to notify separate acquisitions of funeral homes. Also, in March last year, the Chinese Competition Authority announced that it issued 10 decisions imposing fines to leading tech companies for failure to notify reportable mergers. And last month, the Moroccan competition regulator sanctioned for the very first time a company for failure to notify a deal. The gun jumping is another area where companies need to be cautious. For example, last month, the French Competition Authority fined an alcoholic beverage company for implementing the acquisition of one of its main competitors before obtaining the approval from the French competition authority. According to the decision, the acquiring company exerted a de facto control over the target by influencing its strategic, commercial, and management decisions. It is worth mentioning that some of the evidence was found by the French enforcer during a dawn raid conducted at the party's premises only a few weeks after the approval of the deal. At the European level, it is worth also mentioning the ongoing investigation into the Illumina Grail deal in relation to a potential violation of the standstill obligation. Another way company may be sanctioned for breaching procedural rules is by giving misleading information to competition authorities. The European Commission has already sanctioned companies for providing incorrect or misleading information on several occasions. For instance, in 2017, Facebook was fined 110 million euros for providing misleading information in the context of its acquisitions of WhatsApp. 2 years later, General Electric was fined 52 million for a similar offense. And last year, Sigma Aldrich was fined with a fine of 7.5 million for providing misleading information. There are also examples at the national level. For instance, the competition authority in Israel sanctioned a company for withholding data relating to messages between the merging parties in August 2021. So, all in all, my takeaway message is that merging parties should be aware that breaching procedural merger rules can come at a price, as very significant enforcement action in this area.
Great, thanks, Jean-Julien. So let's turn to Bryony. So although the approach to merger control seems to have been tightened, Jean-Julien mentioned that some competition rules have been relaxed during the pandemic. Does this have any continuing impact on M&A transactions?
Well, thanks, Ben. The main impact that this is likely to have in M&A transactions is actually where the target in a deal in particular is operating in a sector in which those rules were relaxed. And in this situation, it will be very important to confirm that the target's activities during the period fell within the scope of the exemptions or the derogations that were in place, to make sure that it complied with all of the relevant competition rules. Just to give a bit of background on the relaxation of the rules, so at EU level, for example, the European Commission issued a temporary framework for assessing antitrust issues relating to cooperation in response to urgent situations stemming from the COVID-19 outbreak. And this covered possible forms of cooperation between undertakings in order to ensure the supply and distribution of essential products and services during the pandemic. So in relation to the health sector, which is the one that you'd think of immediately, it allowed companies to engage in a certain level of coordination and exchange commercially sensitive information to adapt production and stock management and sometimes distribution to address the shortages that we all saw arising. Now, this kind of coordination and information exchange would usually have been problematic under the competition rules, but was permitted in the exceptional circumstances arising, provided that the measures met certain conditions. However, the Commission did also include a warning in that temporary framework that it would continue to closely monitor market developments to detect instances of undertakings taking advantage of this particular situation to breach EU antitrust law. And it's worth noting actually that although the temporary framework itself had a very particular focus on the healthcare and the pharmaceutical sectors, in theory it potentially related to cooperation projects aimed at addressing the shortage of all essential products and services during the pandemic. And the Commission in fact extended similar derogations in other sectors. For example, in agriculture, the competition rules were relaxed in relation to milk, flowers, potato, and the wine sector. And the Commission also provided guidance to the European Automobile Manufacturers Association to confirm how its members could interact with some of their suppliers to stabilise supply chains during the pandemic without infringing EU competition law. And these kind of derogations didn't just happen at EU level. So national competition authorities did the same thing in their individual jurisdictions to help undertakings cope with the emergency situations. So in England, for example, they're related to groceries, dairy produce, certain maritime crossings, and also certain health services. But notwithstanding all of this, as I mentioned, authorities continued to emphasize that they would take action against companies who were taking advantage of the pandemic to breach antitrust law. Examples arising in various circumstances, such as in the UK, the Competition and Markets Authority opened investigations into certain pharmaceutical companies on the basis of excessive pricing concerns. So coming back to the M&A context, if a target active in one of these sectors is being acquired, we'd recommend conducting enhanced due diligence and raising appropriate competition inquiries just to try and identify any potential liabilities for the purchaser. And in that context, depending on the outcome of those inquiries and so on, we'd strongly recommend including appropriate warranties and/or indemnities in transaction documentation to further protect against any risk that might arise.
Great, thanks, Bryony. So I know quite a few of the people joining us today are in the private equity industry, and I'm sure they'd be interested to know which entity would be potentially liable for breach of competition law within their portfolio.
So it's an interesting question, because broadly speaking, there are a couple of relevant principles that come into play here. The first is that the portfolio company would itself be liable for its infringement. And so if that company is being acquired, the liability would travel with it. And actually it's worth flagging that this isn't something that can be avoided by or circumvented by simple restructuring, because there's a principle of economic continuity that would come into play. So essentially, if the infringing entity no longer exists, the regulator would look to the entity that absorbed it or has taken on responsibility for it. And again, as Jean-Julien mentioned when he was talking about the procedural fines and so on, penalties for breaches of competition law can be significant. And so any infringement resulting in a penalty could have a major impact on the value of any acquisition. And a further consideration beyond that is that actually anyone suffering harm as a result of an infringement of competition law can bring a private action for damages. And a European court decision in 2019 confirmed that these types of actions could also be brought against an infringer's economic successor. The original entity no longer exists. So, any breach could therefore potentially result in significant costs for any acquirer. And then secondly, it's worth noting that any company that controls the infringing entity at the time of the infringement would also be liable for its conduct. And the concept of control from a competition law perspective for these purposes actually extends beyond a simple majority shareholding, to also include significant minority investment, where the financial investor exercises what's called decisive influence over the portfolio company. And this can arise in a variety of ways, including the appointment of board directors, certain veto rights, and the provision of certain types of business support. So last year, the European courts actually confirmed that Goldman Sachs should be jointly and severally liable for its portfolio company's involvement in the power cables cartel, notwithstanding that Goldman Sachs, in fact, only held 33% of the financial interests in the relevant fund, which then held the shares in the company. And yet, similarly in the UK, the Competition and Markets Authority has imposed fines on 2 private equity firms which controlled a portfolio company that had engaged in excessive pricing. So as well as emphasising the need, obviously, for appropriate warranties and indemnities in transaction documentation, these cases really do underline the importance of having adequate compliance policies in place, as well as the need to put them in place post-acquisition of any target company going forward. To the extent that any infringing activity continues post-completion, then once the acquirer obtains control, it will become liable from that point onwards for the ongoing infringement. So this is an area that is particularly important, in fact, following the relaxation of some of the competition rules during the pandemic, when things are slightly less certain and there's more of a perhaps grey area. So it really does carry the more general recommendation to ensure that target companies have complied and also continue to comply with the competition rules going forward.
Great, thanks very much, Bryony. So it is 10:28, judging by my clock. So we've still got a couple of minutes left, and I know we have had a couple of questions in from the audience. So let me have a look. So one here for Simon. What experience do you have of clients undertaking technical audits of the source code, and how effective have they been?
Okay, yeah, yeah. So as I mentioned, I have had experience with this and seen this sort of more often over the sort of last 12 months. So there is always an option where there are question marks over compliance, and we've done this on a few deals. But really, it comes down to sort of the level of risk that the buyer or investor is willing to take and their willingness to spend money on the audit. In particular, costs can range from sort of 10 to 15,000 for sort of quite small code bases, up to several hundred thousands, depending on sort of how complex the software is. So it's a judgment call of sort of balancing that risk with the cost. So, and then in terms of effectiveness, I suppose it's just to clarify the way that it works. So what happens is the target's code base is scanned through a specialist service provider's platform that scans the code against its own records of open source terms. So an open source code base. So it can't, sort of in terms of effectiveness, it can't be guaranteed to pick up on everything, because you're sort of relying on the supplier's own software having sufficient data in there to pick this up. But if you're using one of the sort of well-known providers, then you get sort of a bit more assurance on that. But it's always worth bearing in mind that there's sort of little, if any, warranty protection from that sort of service provider, irrespective of paying quite large amounts of money, that their results will be sort of totally accurate and complete. But practically, it can be really helpful. Picks up both compliance risks in terms of flagging incompatible licenses with sort of proprietary use, and it also picks up sort of known security vulnerabilities. So when we have seen it being used on deals, it has been really effective, and has often brought up quite useful information in quite a digestible format.
Great, thanks, Simon. So it's now gone 10:30, so I think we'll wrap up there. So thank you very much to the panelists, Paul, Simon, Katie, Jean-Julien and Bryony. I hope you have found this webinar interesting, and it has highlighted some of the key changes to think about in how you approach M&A deals in these interesting times. If you do have any follow-up questions, please do feel free to reach out to me or the panelists, and we'll do our best to answer them. The next talk in this series is on Thursday, the 7th of June, and we'll be focusing on avoiding other M&A risks and liabilities, so please do join that. Thank you very much for joining this webinar, and I hope you have a great rest of the day. Thanks. Goodbye.